Welcome to the Smarter Money Life podcast powered by Forum Credit Union, your go-to podcast for all things personal finance, where we break down complex financial concepts into simple, actionable steps. Whether you're looking to save more, invest wisely, or plan for your future, we've got you covered. Join us each episode as we bring you expert insights, real-life stories, and practical tips to help you live a smarter money life. Hello, everyone. Welcome back to another episode of the Smarter Money Life. I'm your host, Andy Mattingly, and today we're going to discuss estate planning for every stage of life. Now, whether you're turning 18 or planning for retirement, we've got you covered. And it's more than just the passing of your assets at death. It's about managing and preserving your assets while you're alive. Your estate plan probably is going to evolve over time, depending upon your age, family status, health, wealth, lifestyle, and all those things. So that's why today I'm bringing someone in who knows a lot more about this than I do. It's Ian Keeler, who's an attorney at Clapp Ferrucci, and more importantly, someone who really values estate planning. He's a husband and father who understands how important estate planning can be for his entire lifetime and for his family. Ian, thanks for joining us today.
Thank you so much for having me, Andy.
Well, I'm really looking forward to this conversation. I've known Ian for quite a long time, so I know he's very knowledgeable about this. So please listen to this and get out your notebook and start making some notes on these things. So we're going to start with first, why is estate planning so important for individuals at any stage of life?
Well, it's always good to have a plan and direction for your assets and for scenarios that come up.
Yeah, that makes a lot of sense. Do you run across, any misconceptions from some of your clients about estate planning of like, why they don't think they need it or anything like that?
Well, one of the biggest misconceptions that I run across with clients is them thinking that they don't have enough wealth. And so a lot of people think that it's not till the end of their life that they need to start making a plan. However, planning is good at any stage of life and at any amount of wealth.
Yeah, I do think that that's something that I've heard you talk about before, is that even if you're 21 and don't have anything, you may have some things that you want to make sure someone can help you with, which kind of leads me to my next question. And you've touched on some of these, but what would you consider are kind of the key documents or things that people need to do in an estate plan?
Well, some of the key documents, a will or a power of attorney or a healthcare directive, right? And those are the essential components of estate planning. However, the estate planning process is much broader than that. So for instance, when I meet with clients, one thing that a lot of clients are aware of, but they don't know how it affects the process, are the designation of beneficiaries. So for instance, with accounts, if someone has an account with Forum, instead of that being a probate asset and it going through their will, they can designate a beneficiary on that account, and then it passes outside of probate. And so, that's part of the broader conversation that doesn't necessarily end up in a document that I draft, but is an important part for clients to think about when addressing their estate plan.
Oh, that makes sense. And you just brought up a word that maybe not everyone understands. Would you mind elaborating just a little bit high level on what you mean by probate?
So probate is the court's administration of a will. And so in the legal world, you have kind of two buckets, what are deemed probate assets and non-probate assets. And so your probate assets pass through your will and the designations you make in your will. And then the other set of assets are non-probate assets, and they pass outside of your will. And sometimes there can be easier administration for non-probate assets with respect to beneficiary designations or transfer on death designations. And so that can be an easier administration of transfer your assets at the time of your passing.
That's a very good point, because I think people don't realize how important it is to have these things put in place to make it easier on, whoever you're giving this stuff to or your relatives or whatever that have to deal with settling your estate. The more of these things you can have in and don't have to go through probate and all that will make it a lot easier, even if they've done some of that. So that's a very good point. You talked about, the advanced medical directive. Would you just explain a little bit for people why this is important? And it doesn't even have to be, I guess my understanding of it is you want to have this, even if it's not that it's in a life or death situation, you just might need this, right?
Yeah. So generally, your advanced healthcare directive, or it used to be called living will, but it helps make decisions in the event of your incapacity. And so, with respect to your healthcare, and that can be really important, not just for yourself, but for whoever you designate as the healthcare representative, right? Because that can be a tough and emotional process. A lot of my clients tend to designate family members as their healthcare representative. And so that person has an emotional connection.
Yeah, that's a great point. While we're talking about different pieces of an estate plan, the other thing that you'd mentioned before was the power of attorney. Can you kind of explain why that's important and how that helps in estate planning and helps people, even if they become not able to make their own financial decisions, things like that?
Yeah. So, power of attorney is a document in which you assign someone authority to make your business decisions, and in some cases, your healthcare decisions in the event of your incapacity. It can be really beneficial for making your business decisions for an unexpected circumstance. You can't always anticipate what's going to happen to you. And if you do become incapacitated for any sort of reason, and you don't have something like that in place, then it can be really difficult for someone else to make those necessary decisions, or to pay your mortgage, to access your bank accounts, to do things along those lines without a court order, right? They would have to most likely be appointed a guardian for you if they wanted to access those documents. However, a power of attorney is your decision beforehand. And so it allows them, a lot of times for my clients, for a lot of clients, the power of attorney becomes effective upon the determination of a doctor of incapacity, right? So it's not effective necessarily right away, although you can make that decision, but it's just a means of planning ahead.
Yeah, and that's good. I know that for my parents, they have given power of attorney to two of their children, and it's not upon like they want it so that they can help them with certain things, even now. So they've made it to be in effect and saying, hey, they've given it to kind of specific roles that they want people to pay or to play just to help them out so that they can take some of that burden off and help make decisions for them and not always have to be involved or present at that decision-making process.
And that's a great point. Part of this whole process is that you're in control. And so you're making the decision. You decide when it becomes effective based on your needs and your life circumstances. And that's again, part of this whole estate planning process is one of the key considerations in this whole estate planning process. One of the first steps that we go through with clients is first identifying their assets, right? A lot of people are fortunate enough to have a lot of assets, but you don't necessarily keep a regular inventory of all of those assets. And so the process for a lot of my clients is very beneficial in just specifically identifying those assets. And then the next step is what would happen to those assets now? Some clients, they have beneficiary designations on their accounts that were made 30 years ago that in the event of their passing, they wouldn't necessarily want that today. So it's a process. It's an estate planning process. And it's not just involving those documents. It's making that full assessment of your financials and your assets and what you want.
Yeah, that's a good point. One of the things I was going to ask you, which you already answered, why is it crucial to continually update your beneficiaries on life insurance and 401k and other accounts? And you just hit it. What you did 30 years ago, you may not have been married, you may not have had kids, you might have become divorced, you might have gotten remarried. And if you don't change those things, they're not going to, that's legally binding until you change it. And so you may not be able to pass assets to the people that you wanted to get it. So that's a very important point. And I want to make sure that our listeners understand what you just said there, how important that is, that in my mind, what you just said is estate planning is something that you start and you never stop. You've always got to be looking at it and updating it as your life changes.
Certainly the truth. And I would recommend it on a regular basis every few years, and it doesn't always have to involve an attorney, but it's great to keep that regular inventory of your assets because things can get lost. You can forget about accounts, you can change jobs, you can get a new 401k, and you can lose track of that old 401k.
Yes, that's very, very important. Now, one of the things you've talked about was having a will, and we've talked about those benefits. But another thing that I want to talk about is like naming an executor of your estate. Like, how do you, like if someone comes to you and says, well, who should I name as my executor? What kind of guidance do you give for them and on how they do that?
That's a tough question that clients have a lot of time. First, for the client's peace of mind, you probably want to name somebody that you trust because they're going to be making decisions with respect to your assets, right? But then equal in that consideration, you probably need to choose someone that is capable of performing the duties you're asking with respect to an estate plan, to administering an estate.
Yeah, that's so important about that. I want to dive into just a couple of things that are sort of unique. What should unmarried couples keep in mind when they're planning their estate? I've known of a couple of cases where, and this gets back to like talking about beneficiaries and stuff, where there's been unmarried couples and they never did anything with their estate because they weren't married and they'd been together for a long time and had a lot of assets that were in one person's name or the other. And then one of them passes away and the other one doesn't get it because their family doesn't want to share it with the person they're with.
Right. That's a great question. Yeah. So if you don't have an estate plan and you don't have beneficiary designations with your assets, there's still going to be a transfer of them. And so the Indiana law makes decisions for you, and it makes decisions as to what it thinks might be best. And so those are known as the laws of intestate succession. So without a will, they're going to make distributions of your assets in percentages based on those laws. And those laws in general, they pass to family members. So if you have an unwed couple, then unless there's a specific designation as a beneficiary or a will, then it's unlikely that they're going to receive any portion of this.
And it's so important. And I think people don't think about that. They don't think that, that you need to do that. The other example is, what other things should families do that have children that are under the age of 18? Is there anything specific that they need to make sure they put in place?
Well, one thing that's really important in a will is for an election of a guardian, right? So who's going to take care of your children in the event of your passing? So that's a recommendation that you make through your estate planning documents to a court who ultimately makes that decision. Another thing that can be really important is the formation of a trust, right? And you can do that through your last will and testament. Instead of assets going directly to your children, you can create a trust through your last will and testament that your assets go to, and then they're held for the benefit of your children. Now, a lot of clients think, well, I don't have enough assets for a trust, right? But if you don't put your assets in a trust for your children until your children reach the age of 18, the law is going to imply a trust for those assets for the children regardless, right? So they're going to go into a trust one way or another. The difference is that under the law, when the child turns 18, they get those assets. Now, Andy, I don't know how you were when you were 18, but it wouldn't have been beneficial for me if I received a lot of assets.
Absolutely correct. I think you need to be a little bit older before you get all those assets.
Right. So if the law is going to imply it anyway, right, imply a trust for those assets anyway, why not take a little bit of time and consideration and designate someone that you trust as a trustee, and then designate how you want those assets to be used for your child. Now, a typical simple family trust for the benefit of children has what's known as the HEM standard. So there can be distributions of the principal at the discretion of the trustee for the health, education, maintenance, and support of the child. And so it's an important conversation to think about and to have, because when you pass, you still want to provide for your children.
Yeah, that makes good sense. Do you see a lot of times when people set up those trusts that they also at some point then start making sure, I mean, I know there are some trusts that are like huge, but for the normal person, probably by the time the child is maybe 30 or 35, the trust has been paid out to all of them on their, is there kind of a general rule of thumb that people try to do?
Well, a trust is a contract. So you get to make the
Terms,
right? So if you want it paid out at a certain point, you can do that. It doesn't have to last forever. And actually, there's laws against trusts lasting forever. So you're making your recommendation, or it's not your recommendation, it's a contract, right? It's what controls your assets. So you can, at a certain point, your children are probably will need those assets, and they're building their own family, and that's
right.
what most clients want for their children, right? So you have termination provisions, but it's being in control of those termination provisions and control the assets and how they benefit your children even after your passing. And that's also an important point with respect to what we had talked about previously, beneficiary designations, right? So, for instance, let's say if you have life insurance, if you have I'll give an example. So a married couple and they have 2 kids, right? And they want a trust in their will for their 2 young children in the event of a pass. Let's say for the husband, that his beneficiary designation, his first beneficiary designation on his life insurance is life, right? Well, a lot of times what people do is their second beneficiary designation is their children. Well, beneficiary designations trump probate. Right?
Okay.
So they trump the will and the trust created.
Okay.
So if there's a beneficiary designation on the insurance, those children are going to receive the insurance payment straight out. It's not going to go to the trust. So the proper designation for the secondary beneficiary designation on the life insurance needs to be the trust created by my last will and testament. And then those life insurance proceeds are going to be administered pursuant to the terms of the trust. Because in some cases, life insurance can be, in the event of a young, unexpected passing, that can be your largest asset. Right. So it's important to identify and to make appropriate those beneficiary designations in those accounts and life insurance policies.
And that's important because I think a lot of people, when they see those things, they may have a trust and set up through their will and that, but they don't think about that when they put it on the designations, because they're thinking about, well, this is how I have it set up in my will, and so it'll just go to that. And so that's a very important point that I think a lot of people probably don't have set up correctly on all of those beneficiary designations, because I'm pretty sure they've probably just put their kids in and they might even have a trust ready for them. We've talked about that, you should regularly review and update your estate plan, but are there some common triggers that if this happens, you need to then make this change in your estate plan and not wait for, like if you're doing it every 3 years, but if something happens, what are some of those life moments that happens that you say, I need to go and update my estate plan right now because something's changed that I need to do?
Well, it's going to be your major life events. Right. So when you have kids, now you have additional responsibilities. So you need to start thinking about guardians, potentially a family trust. Right. And then once you have a job change or retirement, right, or you start having grandkids, it's going to be those major life events. Another thing to consider is that throughout most of the U.S., there's reciprocity. So if you move, your will is most likely going to be enforceable in another state. However, if you want to make changes wherever you live at that time, the will needs to be written in that state, right?
Okay.
So if you need to make a change, it needs to be done in that state. So, moving can be another situation in which you may need to consider your estate plan.
That's a very good point. I don't think a lot of people think about that one as being a trigger that you might have to do some changes with your estate plan. When you work, I want to kind of come back to families. When you work with families, and let's say that it's older that they have older children. So we've gotten away from their needing to be a trust set up because they need the benefit. Do you see that some people still want to set up a trust because they don't want to give even if they're 24 or whatever, that they want to make sure that some of that also goes to their grandkids because you brought that up? Do you see people then adjusting it and saying, well, okay, here's a trust and I'm going to give it to you, but I also want some of this to be available for you to use for your grandkids because I want to help with them with their education if I'm not around, things like that. Do you see any of those kind of nuances as people set up things?
Absolutely. The one thing that I would say that strikes me every time I go through the estate planning process with clients is how different everyone's. There are people who, for whatever reason, want to make unequal distributions to their beneficiaries, right? They've had different life circumstances and different things have gone on during those lives. So certainly there's that. And then there's also some people who may have children who have special needs and they want to continue to provide for them even after their passing. So they'll set up a trust for that purpose. So absolutely, yes, everybody's different. And that's why I think the estate planning process is so important. And that's for any number of things, including like the healthcare directive. When people are making decisions about their healthcare decisions in the event of their incapacity, people are all across the board with how they feel on that, and a lot of that stuff is stuff you don't think about until you're presented with the question. Then you have to give an answer because we're writing it down, right? And I've always found that clients find those questions and working through that process to be really valuable.
Yeah, that makes total sense. Now I'm going to ask you, I don't mean for this to be a silly question, so don't laugh at me, but everyone sees on TV that it gets so granular. It's like, well, this kid gets this, this famous painting and this person gets this, whatever. Do you see people that get into that, or is that more things that they say, well, this is what I'd like to see happen, or to give that? Or do some people get down to like how they're giving away all the family heirlooms, we should say?
So typical answer in the law is it depends. So when you're giving away particular items of property, that in the trust and estate world, that's known as a specific bequest. And so we do see specific bequests, but in general, the majority of assets are percentage based. So normally it's just an aggregation and then a separation based on percentages. Sometimes in the document they'll allow. I've had some clients who have requested kind of like a fantasy football snake draft. So yeah, people can get granular in.
Sure. That makes a lot of sense. So I have kind of come to all the questions that I have, but do you have any other final thoughts or, maybe nuggets of information for our audience here for, estate planning, whether they're starting or they've been doing it? Any final thoughts you want to share?
Well, my final thoughts would just be for anyone who's listening to this podcast to consider working on their estate plan and start with doing an accounting of your assets, right? And I think that once you do that and thinking about where they might go in the event of your untimely passing, you'll be in a better position to decide, well, maybe I do need to decide that some decisions on my estate plan.
Yeah, that makes a lot of sense. So hopefully what you've all heard today is estate planning doesn't have to be difficult. You just kind of have to do it. And I recommend, not just because Ian is sitting here, that you seek the counsel of an experienced estate planning professional because they can really walk you through. As you saw, Ian shared a lot of tips today that a lot of people probably don't think about. So, it comes down to being prepared is always a winning move. That's all for this episode of the Smarter Money Life podcast. Thank you for joining me. I hope you found our discussion helpful and inspiring. You can find more resources on the Smarter Money Life page at forumcu.com. Remember, making smart financial decisions is a journey, and every step you take brings you closer to your financial dream. Be sure to tune in next time for more tips and insights on managing your money. Until then, stay smart and financially savvy.